I want to thank George Rackus and all of the organizers of the conference for inviting me to participate. My invitation grew out of that work that my students did several years ago through an invitation from Manny Demos, who many of you know, who was a graduate of our law school. And we prepared a paper on Turkey's compliance with its international obligations toward the Patriarchate and the Greek Orthodox community in Turkey. So I am, in a sense, today substituting for my students. They're the ones who became expert on these issues. They taught me a little, but I do not claim to be an expert on Turkey or on the right to religious freedom. I speak very much as a human rights generalist and as someone who teaches human rights advocacy in a clinical context where we work on real projects. So what I want to do is outline Turkey's obligations toward national minorities under international law. And I thought it would be helpful and perhaps in some ways a little more interesting if I tried to put this in a little bit of a historical context, starting with the Treaty of Lausanne, but then also looking later at the evolution of international law, the relevant international human rights law, particularly how it actually functions, and a little bit about its strengths and its weaknesses. So I want to focus particularly on a key philosophical turn, that distinguishes the early human rights law from the period after World War I to the period after World War II. And I'll start by looking at the structures that have bound Turkey since the end of World War I, then the development of those few new treaties after World War II that provide mechanisms for enforcement, but as we'll see, those are very weak means of enforcement, and they lack specific protections for national minorities. And then we'll look at Turkey's ratification of the European Convention on Human Rights, and then at the post-Soviet resurgence of interest in the protection of national minorities. And finally, a little bit of an overview of how all these obligations come together now. So as I said, there's kind of an ideological shift in between the aftermath of World War I and the aftermath of World War II. The Treaty of Lausanne, as I think many of you know, was part of a system of minorities treaties that were the first attempt in modern international law to codify the rights of national minorities. The treaty was not unique. There were a number of treaties that were signed immediately after the end of World War I and the dissolution of the Ottoman and the Austro-Hungarian empires. And they sought to protect minorities, particularly within a number of nation states, many of which had been arbitrarily created through a sort of redrawing of the geopolitical map by the great powers. Again, I think most of you know more about this than I do, but the Treaty of Lausanne required Greece and Turkey to provide specific protections to their religious minorities, Muslims in Turkey, in Greece, and the Greek Orthodox community, respectively, in Turkey. Those who were remaining in each country after the conclusion of World War I. So I just want to mention a few relevant provisions. One's already been mentioned, that's Turkey's obligation under the treaty to keep the treaty obligations as fundamental law. No law can be made that supersedes the Treaty of Lausanne obligations. Substantively, it provides for a number of things: protection of life and liberty of all inhabitants, regardless of nationality, language, race, or religion; freedom of movement, civil and political rights, including equality before the law; freedom of minorities to speak their language and practice their religion; the right to establish social, charitable, and religious institutions; the right to be educated in their own language; the right to determine issues of family law and personal status according to the customs and laws of the minority; the right to protection of places of worship, cemeteries, and charitable foundations; and the right to be free from compulsion in religion. Article 44 of the treaty provided for enforcement of these provisions through the Council of the League of Nations and through the Permanent Court of International Justice. These treaties raised concerns then about key issues that are still very much at the heart of debates about international human rights today. In particular, the continuing criticism that there is a discrepancy between the obligations of so-called big states and little states. And I'll come back to that a little bit. So what are we talking about? After World War I, it was only the new Central and Eastern European countries that were obligated by these treaties, and Turkey and Greece. Not France, not Germany, not England and Russia, which saw minority safeguards as unnecessary for themselves. Although modern human rights law is universal, at least in theory, in application, this imbalance between the responsibilities of weaker and of more powerful states under international law remains a central focus of critics of the human rights movement. One example, I think that's very current, is the way many criticize the International Criminal Court as being a court only for Africa, so far. Countries subject to the post-World War I treaties saw themselves as, saw the treaties as limiting their sovereignty and infringing their right to self-determination, since the League was allowed to influence national, religious, and educational policies in these countries. Also, these countries felt that the treaties suggested they were not competent to deal with these sorts of internal matters. And finally, the inequality in the applicability of the treaties meant that minority rights were not seen then as universal rights, but really as a matter of foreign policy, a matter of power politics. There was binding law for the smaller states, subject to the minority rights treaties, but for powerful states there was no accountability except through diplomacy. After World War II, we see a philosophical shift. The underpinnings of the treaties after World War II are drastically different from the minorities treaties. The difference between these earlier minority rights protection schemes of the earlier period and the scheme that's emerged alongside the United Nations system is largely a result of the reaction to the Nazi regime and its own invocation of the rhetoric of national minority protection for its nationalist and expansionist purposes. The rise of the Nazi regime, including this use of minority protection language, discredited the League of Nations and led to the disintegration of the Council of the League and of the system that was set up to put the minority treaties in place and to be their means of enforcement. After World War II, the international rhetoric surrounding minority rights became about protection, not about self-determination. The new post-war treaties had a more universalized language, and minority protection was framed in terms of individual protection rather than terms of the rights of minority groups. Neither the UN Charter nor the Universal Declaration mention specifically national or religious minority protection. So what are Turkey's relevant obligations under the newer post-World War II international legal regime? Well, I want to start by mentioning customary international law. The Universal Declaration of Human Rights was adopted by the General Assembly in 1948. It's not a treaty, it's not binding directly on states, but it's widely considered to express customary law. For those of you who aren't lawyers or international lawyers, customary law is a sort of strange form of international law that in effect is binding on states even though it hasn't been expressed in treaties to which states have agreed to be bound. And it's based on the practices of states, and they're acting out of a perceived sense of legal obligation. So the Universal Declaration contains many protections against discrimination that are relevant, particularly equal rights and freedom, irrespective of race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Article 7 says that all are equal before the law and are entitled without any discrimination to equal protection of the law. So there is a prohibition against discrimination, against discriminating against individuals on the basis of their membership in these various categories, including religion. But any notice of membership in a national minority is noticeably absent from this first document of the post-war period. It also includes the right to own property, alone as well as in association with others, principle that no one shall be deprived of of his property arbitrarily, the right to freedom of thought, conscience, religion, and that right includes freedom to change one's religion or belief, freedom either alone or in community with others and in public or private to manifest one's religion or belief in teaching, practice, worship, and observance, and the right to freedom of opinion and expression, which includes the right to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. And finally, the right to freedom of peaceful assembly and association. The first binding treaty that's relevant is the International Covenant on Civil and Political Rights, the ICCPR, which Turkey ratified in 2003. I want to note just particularly one contrast in its terms. Article 1 says that all peoples have the right of self-determination. By virtue of that right, they shall freely determine their political status, freely pursue their economic, social, and cultural development. Article 27 says, in those states in which ethnic, religious, or linguistic minorities exist, persons belonging to such minorities shall not be denied the right in community with the others of their group to enjoy their own culture, to profess and practice their own religion, or to use their language. So the wording for the right to self-determination in the first article is about the whole people of a state to determine their fate politically, and it's about having a right. It's framed in positive terms. For minorities, it's framed negatively, and it's about individual members who cannot be denied their rights. Turkey's also ratified the Race Convention, but it focuses on race, and I'm not going to talk about it today. It doesn't focus on other forms of minority, although there's some debate about what race can be interpreted to mean. And then, of course, Turkey has ratified the European Convention of Human Rights in 1954. Article 14 of the European Convention prohibits discrimination on any grounds, such as race, sex, color, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth, or other status. So its use of this language as any grounds such as, and the phrase at the end, or other status, makes the discrimination clause of the European Convention very expansive. And it's important, I think, that unlike the Declaration, the Universal Declaration, it does specifically protect against discrimination on the basis of association with a national minority. So it brings the term national minority in, but it's still protecting individuals who are members rather than offering protection of the group itself. As has been mentioned, Turkey has not ratified the Council of Europe's Framework Convention for the Protection of National Minorities, the one modern treaty that is explicitly aimed at the rights of minority groups. And I'll say a little bit more about that later. I want to mention one instrument of what we call soft law. It's not a treaty, it's not binding on states, but it is an authoritative source of principles, and it's often turned to for help in defining or interpreting binding obligations, and that's the Declaration on the Rights of Persons Belonging to National or Ethnic, Religious or Linguistic Minorities of 1992. And that frames these rights in terms of positive obligations on the part of states. It says states shall protect. It's used stronger languages in some ways than the treaties, so if it were obligatory, it would set a higher bar, in a sense, for states' duties to minorities, because it would oblige them to take various positive measures to protect these minorities rather than just refrain from certain kinds of discrimination. But this tension remains between the modern notion of individual rights and the older notion of collective rights. The rights belong to individuals belonging to these minority groups. What I want to focus now on is the issue of enforcement of obligations under international law. I'll start again back with the Treaty of Lausanne. The Articles 37 and 44 are most pertinent. They did provide for an enforcement mechanism. Article 37 says that the treaty is above all national laws. In Turkey, Article 44 provided for the jurisdiction of the Council of the League and of the Permanent Court of International Justice, and Turkey consented to that jurisdiction. The enforcement authority of the Permanent Court of International Justice, including for the Treaty of Lausanne, formally passed to the International Court of Justice after the end of the League of Nations. But the International Court has jurisdiction that is only confined only to states and between states. So for this enforcement mechanism to have any effect, technically, one of the other parties to the treaty would have to bring an action to the International Court of Justice. Greece, Britain, France, Yugoslavia's successors, Japan, Italy, Romania, they would have to bring a case against Turkey for violation of the treaty's terms. In the past several decades, since the end of the Second World War, enforcement of human rights norms have become a somewhat more salient topic. The core human rights covenants and treaties developed and adopted after the war provided enforcement mechanisms for the norms that they enshrine. These are largely treaty committees, and they're responsible for monitoring states' conduct and their compliance with the treaty's provisions, mostly through reporting requirements and through the committee's issuing of observations and recommendations. I'm not going to go into a whole analysis of that, but this method is notoriously lacking in enforcement teeth. The regional human rights courts and systems enforce their region's treaties and make decisions that are binding on the state parties to those regional treaties. They do hold states accountable for their violations, and that, of course, is the European Court of Human Rights, the Inter-American Court, more recently the African Court. Also, some states' domestic courts have begun to apply international human rights law in their decisions and to hold individuals and governments accountable for violations domestically of their international obligations. That's complex, it takes different forms, but interesting examples these days are in South Africa, Colombia, Spain to some extent, and in interesting ways even in the United States. The first optional protocol to the International Covenant on Civil and Political Rights established an individual complaint mechanism for the ICCPR's committee, which is called the Human Rights Committee. Parties to the optional protocol agreed to recognize the competence of the committee to consider complaints from individuals or groups who claim their rights under the covenant have been violated. Turkey ratified the optional protocol in 2006. It accepted the jurisdiction of the committee to hear individual complaints. However, it's made reservations to the optional protocol which do limit the committee's jurisdiction over its individual complaints in some procedural and substantive ways. The European Convention of Human Rights placed Turkey under the jurisdiction of the European Court of Human Rights, and in 1987, Turkey accepted the jurisdiction of the European Court to hear individual applications against Turkey pursuant to that treaty's Article 25. Again, Turkey has not signed the Framework Convention, and the convention is described as the Council of Europe as designed to protect the existence of national minorities within the territories of the parties, and is designed to be the first legally binding multilateral instrument concerned with the protection of national minorities in general. So now, at the beginning of the 21st century, I think we see in an interesting way the new sort of meeting the old in the human rights system. The collapse of the Soviet Union has brought about a number of relevant critical developments that I'd like to mention. Although enforcement mechanism grew out of the post-World War treaties, in one author's words, the national minority rights were non-existing in modern international law. But a rise in concern for national minorities has coincided with this rise in a general concern for enforcement. And it has particularly entered into European political discourse alongside this resurgence of national minority conflicts in Europe. So it's reminded us as the same author has stated, liberalism has not fully accommodated issues such as diversity, nationalism, identity, subnations recognition, and plural governance. So again, after the fall of the Soviet Union, the loosening of the communist regime's governance of a number of ethnically diverse states, particularly in the Balkans, there was a reawakening of the need for minority protection. And so some of the substantive obligations from the older treaties have started to come back into play. In terms of Turkey and holding Turkey accountable, I think the most interesting development may be how the older law has at least entered into consideration in the adjudication of international legal claims. In a way, the Treaty of Lausanne meets the European Court of Human Rights. And the European Court has proven to be a fairly robust mechanism for enforcement of Turkey's international legal commitments to minorities. You're all familiar with a number of cases. I won't go into detail about them, but in at least one, the court mentions the Treaty of Lausanne. It did not base its decision on the Treaty of Lausanne, finding that Turkey had deprived the Patriarchate of its property without appropriate consideration. It didn't base it on the Treaty of Lausanne. The decision was necessarily based on violation of the convention or its protocol. But the court included the treaty in its discussion of law that's relevant to the case after the parties had introduced it. And that discussion of relevant law beyond the convention, which is a usual practice of the European Court in its judgment, marked the first time that the European Court, in its judgments, had ruled on these sorts of policies toward Turkey's non-Muslim religious foundations. And in holding that it had, in mentioning the Treaty of Lausanne, it was in a sense reminding the parties of its continuing obligations. The European courts had successive judgments since then against Turkey in cases lodged by Armenian foundations on the same issue. It's included the Treaty of Lausanne in its discussion of relevant domestic law and a number of other judgments concerning violations of minority rights in both Greece and Turkey. Again, while violations of the treaty are not the basis of the court's judgment, the court has informed the parties that are raising these violations of the treaty that the court is apprised of those obligations as well. And these examples, I think, illustrate the increasing willingness of the European Court to enforce religious minority rights in Turkey, particularly as the EU accession process proceeds and continues to generate pressure on Turkey to comply with the court's decisions. One source has stated that the court has been, quote, instrumental not only in strengthening the impact of the European Court of Human Rights jurisprudence on the protection of human rights in Turkey, but also encouraging marginalized individuals and minorities other than Kurds to litigate in Strasbourg. So these cases do show, in a way, how these two different philosophies have come back together. It's individual petitioners, as opposed to states before the International Court of Justice, seeking liability for violations committed by states. The old treaties that have more robust protection for minorities but no real means of enforcement are being brought back up by individuals to assert the responsibility of the states toward their members. I want to conclude by sort of tying this together a little bit in terms of this change after the fall of the Soviet Union. In a sense, it's brought us around the circle a little bit. Have a historical moment that caused a lot of political, economic, and demographic problems, including the wars in the Balkans, new floods of refugees in the region, and people started looking back to the minorities treaties for guidance on what to do. So minority rights protection came back into the discussion, and we saw the re-entrance of the old treaties now being invoked by individuals before the institutions of the modern era to help interpret and strengthen the rights under these post-World War II treaties of individual members of the old minority protected groups. So Turkey's obligations today under international law are an amalgam of protections that were instituted 100 years ago and those developed since World War II. What I think does make the Treaty of Lausanne still relevant, at least as background to the more modern obligations, is this use by individuals representing these same groups that the treaty was designed to protect. The treaty offers an ideological underpinning for these cases, and the European Convention and the European Court provide a pragmatic vehicle for enforcement. I want to close just by reiterating what some have described as the great post-war human rights compromise. That was the establishment of strong human rights norms in the main treaties that we know about, but weak institutions of enforcement. The formal institutions of enforcement have been weak. But enforcement in international human rights talk is not just about those formal mechanisms. It's also a creative process that draws on all legitimate means to bring about pressure for greater respect for human rights. It is fitting and obvious, I guess, that we're meeting today in the European Parliament because it's the increasingly vital European Court of Human Rights acting in the context of the EU accession process that's begun to show promise for holding Turkey accountable for its international human rights obligations and for putting pressure on Turkey to comply with those obligations. I guess I'd like to just finish with a little more personal note. Others have referred to the broader world, and I was thinking about that. I think we live in a very troubled time when hatred and fear are not only the currency of the extremist, but have found their way even into the mainstream of politics in places where we may have thought we were beyond that, like the United States, which has its profound tradition of welcome and diversity and defense of dignity. So if you'll indulge me for one moment, I'd like to close with a quotation that for me has been something that I turn to when I want to remind myself that we need to be patient and that we need to sustain hope. And this is a quote from the Anne Frank's diary that many of you, I'm sure, are familiar with, where she says, "I must uphold my ideals, for perhaps the time will come when I shall be able to carry, excuse me, to carry them out." Thank you.